Most UK renters assume that once you sign a tenancy agreement, your landlord can pretty much enter the property whenever they want, let themselves in for inspections, pop around unannounced, use their spare keys, or turn up with contractors with barely any warning. A lot of tenants feel uncomfortable about it, but they stay quiet because they assume the landlord owns the property so they can do what they like. But legally, that is not how it works. When you rent a property in the UK, it becomes your home. And one of the most important legal protections you have is something called quiet enjoyment. Despite the name, this has nothing to do with noise. It is a legal right that protects your privacy and your right to live in the property without unnecessary interference. A lot of landlords either don't fully understand that or rely on tenants not understanding it themselves. Today, I'm breaking down when a landlord can legally enter your home, when they can't, what counts as harassment, what counts as an emergency, and what your rights actually are in 2026. Let's start with the biggest misconception first. Your landlord cannot just let themselves into your property whenever they feel like it. Not because they want to check something quickly, not because they're in the area, not because they gave you an hour's warning, and not because they still have keys. In most situations, landlords are legally required to give at least 24 hours notice before entering the property, and the visit has to happen at a reasonable time of the day. That normally applies to inspections, repairs, viewings, safety checks, maintenance visits, and valuations. And importantly, notice alone does not automatically mean permission. A lot of tenants don't realize this part. A landlord should still be getting your agreement before entering, unless it's a genuine emergency situation. And this is where some landlords cross the line. Some tenants experience landlords repeatedly turning up unannounced, letting themselves in with spare keys, entering while the tenant is asleep, bringing estate agents around without proper agreement, opening bedroom doors in shared houses without notice, using inspections as intimidation after a complaint has been made. This is not normal landlord behavior. And depending on the circumstances, it can potentially become harassment. The law recognizes that tenants are entitled to privacy inside their homes, even if they don't own the property. And this is where many renters feel trapped because they worry that pushing back will somehow get them evicted later. But tenants have far more protection now than they used to. So what actually counts as an emergency? Because this is the main exception where landlords can legally enter without notice. A genuine emergency would normally mean something that creates an immediate risk to life, the property, or neighbouring properties. Things like a major water leak, a fire, the smell of gas, a burst pipe, serious structural danger, an active electrical hazard. In those situations, a landlord may need immediate access to stop damage or keep people safe. But here's what does not suddenly become an emergency: routine inspections, checking cleanliness, showing new tenants around, measuring rooms, checking smoke alarms without warning, just wanting a look. A landlord cannot simply label something an emergency because it is convenient for them. Spare keys are another huge area of confusion. A lot of landlords and letting agents keep spare sets of keys, which in itself is completely normal, but keeping keys does not give them unlimited rights to access the property whenever they want. Tenants still have a legal right to privacy and quiet enjoyment. And this matters because some renters feel pressured into accepting behavior that is actually inappropriate or unlawful because they think the landlord owns a property so they can do what they like. Ownership and access rights are not the same thing once a tenancy exists. Now let's talk about inspections, because this is where a lot of conflicts happen. Most tenancy agreements include clauses allowing periodic inspections, and in principle, that's completely normal. Landlords do have legitimate reasons to inspect their properties occasionally, but inspections still have to be reasonable. If a landlord is trying to inspect constantly, turning up every few weeks unnecessarily, or using inspections to pressure or monitor tenants excessively, that can become problematic very quickly, especially if the tenant has recently reported mold, challenged a rent increase, disputed deposit deductions, complained about repairs, or contacted the council, because repeated unwanted visits after complaints can potentially form part of a harassment pattern. Always keep communication in writing where possible. Text, email, screenshots, and written records matter. Now let's talk about harassment properly, because many tenants don't realize how seriously the law can treat this. Landlord harassment is not just shouting or threats. It can include repeated unannounced visits, entering without consent, intimidation, cutting off utilities, excessive monitoring, threatening behavior, interfering with the tenant's peace and comfort. In serious cases, unlawful harassment and illegal eviction are actually criminal offences, not civil disagreements, criminal matters. Councils can investigate, courts can award compensation, and landlords can face major legal consequences. A lot of tenants are scared to say no because they think if I upset the landlord, they'll just evict me. Historically, that fear stopped many renters asserting their rights. But with Section 21, no fault evictions abolished in England from May 2026, landlords now need a legal ground to evict you and must follow the proper legal process. That does not mean tenants should become hostile or refuse all reasonable access requests, but it does mean you are no longer expected to simply tolerate behavior that breaches your rights because you're scared of retaliation. So what should you actually do if a landlord keeps entering without notice? First, keep everything calm and in writing. A simple written message saying please give proper notice before attending the property in future is often enough to solve the problem. Keep screenshots, keep emails, keep records of every visit. If things escalate, you can contact your local council's tenancy relations team, shelter, or citizens advice, because once patterns are documented, tenants have a far stronger protection than many realize. The biggest advantage landlords have always had is that most tenants don't know their rights. That's why people tolerate behavior they didn't have to tolerate, accept pressure they didn't have to accept, and feel uncomfortable inside homes they are legally entitled to peacefully live in. If this was useful, subscribe, because we're covering landlords, employers, debt collectors, bailiffs, and all the situations where knowing your rights changes the outcome. This is general information, not legal advice, but it's accurate and it's yours to use.